Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 384 of the FCPA Compliance Report. Today, the FCPA Compliance Report is sponsored by my new book, The Complete Compliance Handbook. The Complete Compliance Handbook incorporates the most recent pronouncements and guidance from the Department of Justice, including its 2017 Evaluation of Corporate Compliance Programs and the new FCPA and Corporate Enforcement Policy. It provides the most up-to-date advice on what constitutes a best practices compliance program. In this single-volume compendium, I've brought together the top ideas, topics, and techniques you can incorporate into your compliance program, literally in 31 days to more fully operationalize your compliance regime. If you want one volume to guide you in operationalizing compliance, this volume is it. It's available on Amazon.com. Type in the Complete Compliance Handbook. Or if you'd like an autographed copy, you can shoot me an email or buy one from my site, FCPAComplianceReport.com. Today I have Nate Lankford. Nate is a partner at Miller Chevalier, and we're here to talk about the always informative FCPA review. This is the FCPA Spring Review 2018 by Miller. We take a look at some of the statistics and interesting information available in the the review, including the uptick in declinations, what does it mean, the prosecution of individuals or lack thereof, some of the key points from enforcement actions in Q1, the international developments in anti-bribery and anti-corruption. We take a look at digital realty and its implications, and then we take a look at one of the key components, or at least interesting components, of last year's new FCPA corporate enforcement policy regarding messaging, instant messaging, and messages that deleted, and how the Department of Justice is expecting companies to deal with this. This is Tom Fox. I'm the Compliance Evangelist. Thank you for listening to this episode of the FCPA Compliance Report. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back for another episode, and you're in for a real treat today because I have Nate Lankford with me. He is a member at Miller Chevalier, and he is going to visit with us about Miller's always informative quarterly FCPA review. This one is Spring 2018. So, Nate, with that introduction, thank you so much for taking the time to visit with me today.
Hey, thanks a lot, Tom.
So, Nate, as always, the quarterly review has some great information. So I thought that we might be able to go through some of it. The first one was, I think a lot of people they have in their head that there's been an uptick in declinations, but they can't really point to anything solid to tell them that. Did the report note one way or another whether there had been an uptick in declinations?
Yeah, one thing we have seen is an uptick in resolutions without enforcement. And these are situations where we wouldn't have much insight into the reasons for the agencies not taking enforcement actions with these companies. So we're not, the term declinations is, of course, a term of art where the agencies have determined that there's actual wrongdoing and they choose to walk away from it. And we're not seeing stated declinations in Q1 under the DOJ's new enforcement policy. The first one is actually in Q2 that just came out a few days ago that we'll cover in our next review. It was done in Bradstreet, where the SEC had a settlement with them, but the DOJ declined. But Tom, I think this is part of a broader sort of discussion, this declination question of that we hear from many people is, whether we're in an era where under the new administration that the FCPA is being enforced less aggressively. And I mean, if you'd like to take a few minutes to talk about that question and that potential trend, I'm happy to get into that.
Sure. So what does either of the reports say, or what are your thoughts on that, Nate?
Well, we are starting to see, we're a year into the new administration, obviously, and we're starting to see some potential trends Overall, we're not seeing a dramatic shift in enforcement, but rather some indications that there may be changes. I think overall we're still in a wait and see mode, but there's certainly some signs of a slowdown in enforcement, and we are trying to parse whether this indicates truly less aggressive enforcement or whether it's a more nuanced picture. This Q1, we saw 3 relatively low value enforcement actions against corporations, 2 resolutions, guilty pleas with individuals. This is slightly below the average that we've been monitoring in Q1 since 2008. But overall, if you look at the trends over a decade and you look at, say, 2017, how that fits in, the enforcement, the rate of resolutions in 2017 was basically on par with the average over the past 10 years. If you take out a couple of big spikes in, say, 2016, 2010, what we see is pretty steady enforcement. But of course, that begs the next natural question of whether these cases were just in the pipeline from the Obama administration and that they were just closed out last year and can't really tell much about the new administration from it. So we, of course, look deeper at this issue of to what extent are we seeing new investigations start? So we get some sense of how robustly the agencies are actually going after this under the Trump administration. And what we're seeing is similarly consistent rate of new investigations through 2017. We saw 30 that we could identify from media reports and public disclosures last year. So that tells a story where there is continued robust investigation activity, and these resolutions without enforcement that we were talking about are also part of the picture, where we see those in themselves are evidence of strong investigation activity. The extent to which they're resolved without enforcement, could signal any number of things, whether it's increased sort of effort to clear their list of cases that are open, whether it's they're backing away from borderline cases and trying to focus on the real bad actors. It's a pretty nuanced picture, and of course there are many factors that play into when cases are resolved. So that it's really hard to sort of look at it quarter by quarter and discern an overarching trend that way. But I think just the last word on this, there are some large enforcement actions on the horizon, so that we would expect to see in the near term. Societe Generale and Walmart and a German company, Fresenius, have all set aside hundreds of millions in litigation reserves in connection with expected resolution. So I think it's a little bit too early to tell. We're still in a wait and see mode, but basically the investigation risk is still out there, and companies are still very much focused on this issue.
So Nate, one of the things that I've really been thinking about, and the visual representations in the Miller report via your bar charts really lay it out, is the consistency, exactly what you said, consistent numbers of enforcement action, consistent numbers within a range of open investigations, once again noting the anomalies of 2016 and 2010. So I guess I'm really almost coming around to thinking that 1 year or perhaps even 2 is really not a representative or a big enough sample size to see if there's a trend one way or the other. And then if you overlay that last year was really the first year of a new administration, and I think that there was a thought it was of consolidation or perhaps even some clarification from the Department of Justice. Do you see the Department of Justice really kind of feeling its way, or at least the FCPA unit, or is it something different from your perspective?
Well, what we see is, at least from the perspective of hearing public discussions from the officials at conferences and and also just in our dealings with them is very much a continuity of approach. And I think some of the cases that we've seen resolved in this past quarter similarly show a lot of consistency in the way the FCPA's say internal control, accounting controls, and books and records provisions are being interpreted. So I'd say we see a lot of signs of continuity and continued strong interest in investigation. And Tom, if you'd like, I'd be happy to discuss some just these three enforcement actions that we saw against companies this past quarter.
Sure. And really what I thought, if I could ask, were there any key points around either the the investigative aspects or the remediation aspects that the compliance practitioner could draw from those?
Oh, yeah. Well, I tell you, Tom, the one that I've spent the most time thinking about is the Kinross case.
Right.
That I found to be the most interesting case of the quarter. Certainly not because of the amount of its fine, but I think that that in itself is a bit intriguing. Just for your background, or for those who may not be as familiar with the pleadings, Kinross is a Canadian U.S. company that is listed on the New York Stock Exchange and is therefore subject to the accounting provisions of the FCPA. It settled with the SEC for accounting violations related to two operations it acquired in Mauritania and Ghana, mining operations there. And they were cited for having weak controls that may have permitted bribery and inaccurate records. They were fined just under $1 million, and this is obviously really relatively low in the context of FCPA enforcement actions, and so it begs a couple of questions. Well, in this context, why would it have been so low? What kind of factors were they considering? And I think you have to read between the lines a little bit. First of all, the conduct in this case seemed to be very localized, at least in the pleading, taking place in the African operations, and possibly presenting challenges for jurisdiction of the FCPA. We also see a lot of evidence of extensive remediation here to address the controls issues in these operations. And I think anybody that's in-house compliance personnel or in other roles in-house would recognize the kind of investment that goes into implementing a new ERP system in operations. That's just one part of the remediation they talked about in this case. Was that part of the problem was that they didn't have visibility because of the ERP systems in place there. They implemented new ones. And this is in addition to all kinds of other programmatic improvements they made. And also, there are some indications that they didn't get away pain-free, looking at, say, the fact that the investigation started over 4 years ago, that it was apparently started by a whistleblower, according to media reports, and they were subject to subpoenas. And so I think that it's interesting in that respect, sort of trying to parse and read between the lines of why it would have been such a low penalty considering the kind of issues that they cited. And also, and this is where it goes back to the point about continuity and some lessons for compliance people. It really focuses, this is a case that lays out a very interesting story on how a company can create liability for itself following an acquisition, where conduct that may have happened before the acquisition is not the issue. It's what happened after the acquisition because of slowness and ineffective integration of the new entities. Now, and this is really I think the bottom line here is that, the lesson I've learned from this is that when you are acquiring a company and you're doing your due diligence and integration, you can't do it halfway. Because when you do, say, due diligence, as Kinross did, and you're getting evidence that they have inadequate controls, that they have, and then you do audits after the fact, that you're determined that they have no anti-corruption compliance program, but you don't fix those problems, in the end, what you have is a very substantial record of evidence that management was aware of issues, but that they didn't fix them in a reasonably prompt period of time. So I think that, those 2 points are really the big takeaways from that case for me.
So I do agree with you, Nate, that this case is the most interesting for a variety of reasons, including those you discussed. But I really liked your last point because I think people, or at least executives, don't realize that by having a robust compliance program, that's certainly part one. But uncovering facts and documenting those and presenting them to management for then action or approval to take actions going forward, if a management does not allow that to occur or buries those, has created a auditable trail of management inaction. So that's a great point and a great way to think about a lesson for the compliance practitioner. Nate, one of the things that we did actually have a Supreme Court case that, although not an FCPA case, certainly has implications for the FCPA world going forward. And that, of course, was Digital Realty Trust versus Summers. You guys have a great summary of it in the review. But I was wondering, from your perspective as someone who typically would advise a corporation, what kind of conversations are companies having around this? Is there confusion? Are they trying to increase their presence on their hotlines? What have you seen?
Well, I think this is another issue where the kind of jury is still out on how much this decision will actually practically impact the behavior of people who are whistleblowers in this position of either making that choice to report to the company or to the SEC or to both. I think what we have here, just for the background of everyone, this is where the Supreme Court wanted to resolve a split in how the definition of the term whistleblower is in the Dodd-Frank whistleblower protections and the awards program, and so what they essentially were saying that the whistleblower needs to report the issues to the SEC in order to receive protection under Dodd-Frank. Now, I guess the question is really whether this will have any practical effect, because it really assumes that a whistleblower, when they're thinking about whether to report it to the SEC, are really thinking about retaliation in the future. Because I think a lot of people have the experience that whistleblowers will tend to involve lawyers only after they've suffered retaliation. So it really assumes that whistleblowers will be thinking about this kind of issue in advance. It also assumes that whistleblowers will be making a pretty fine, subtle sort of analysis of whether their protections under other statutes are sufficient or whether they want specifically Dodd-Frank protection, because as many of you know, they have whistleblowers are protected under Sarbanes-Oxley as well, and they get certain procedural and other kind of benefits if they report under Dodd-Frank, but that's a pretty subtle distinction to make. So it's really like thinking. I don't think there's a sense of huge concern about this changing the behaviors of people seeking to report issues, because we're already in this world where the Dodd-Frank award program for whistleblowers exists, and it has increased reporting to the SEC, and so that fact is undeniable. And so the question of how much of that increase is due to these whistleblower protections versus the awards program, it's unclear. So I guess it's still early days, Tom. That's the bottom line.
So, Nate, I'd like to spend a little bit of time visiting with you about a topic that initially came up in late November 2017, but I think it's really been a discussion point in Q1, and that comes from the the new FCPA corporate enforcement policy announced by the Department of Justice, which is now in the U.S. Attorney's Manual. And there was one sort of part in there where the department said it would take into account how companies handled the issue of messaging or other communication services or tools that might self-destruct or go away or burn themselves out after 24 hours or something along those lines. It's really a new technological problem or issue, and it's something that I think investigators from the government and even those investigators, perhaps like yourself, who do internal investigations, find a little frustration. But it's now in the U.S. Attorney's Manual. So what are you hearing or are people talking about at conferences? Is there a sense of how to resolve this issue? Is there any sense of how the government may, the positions they'll take, reasonable or unreasonable? And I know that I've just heard a lot of questions about this topic at conferences.
Yeah, this is certainly a hot topic, and I do remember when the enforcement policy came out. You're reading through it. It seems like obviously some major things that everybody focuses on, with sort of presumption of a declination in certain circumstances, other kind of opportunities for credit, formalizing the pilot program, and then you see this one little bit of additional language, that talks about to get full credit for timely and appropriate remediation, you must meet a certain list of criteria. And there's one tweak to it where it says you must have appropriate retention of business records, prohibiting the improper destruction or deletion of business records, including prohibiting employees from using software that generates but does not appropriately retain business records or communications. Now, for a lot of people, that would just leap off the page, because the way business is conducted internationally and from country to country, office to office, you will see a broad range of work habits that are most often legitimate, where employees, for whatever reason, because of, say, difficulties in internal infrastructure of the company, or a whole host of just user preferences, use certain messaging software for daily business interaction. And in the context of an investigation, that's obviously a huge issue, because that's potential evidence, and there are obvious issues with getting access to that and considering it, collecting it and processing it. And so I think that this is a sign that the agencies were frustrated with this issue in their investigations, and they were kind of putting it on the companies to take some sort of reasonable approach to this. And I think the reasonableness standard is signaled in this by their reference to does not appropriately. That word appropriately signals that they are looking for companies to, say, not prohibit employees from using any type of software that doesn't retain records indefinitely that they can get their hands on. One question that I've heard is, well, are we allowed to have employees use the phone? Because that's a form of communication that doesn't generate a record of the discussion. I think what the agencies are looking for, with the kind of comments that you hear at conferences and in public discussions about this, they want companies to sort of proactively think about this issue. Think about what the work habits of the employees are. Think about what rules exist for appropriate use of software. What rules should they have? And particularly prohibiting the kind of software that Tom you were just mentioning about that deliberately, the whole purpose of using the software, you can make sure that you leave no trace of the communication, clearly creating some sort of circumstantial evidence of an intent to conceal the communication. But otherwise, I think that the agencies are signaling that they're open to companies taking proactive, rational approaches to setting out clear rules for their employees of what kind of software they're permitted to use, and doing the other kinds of complementary compliance program implementation steps around that, to make sure that those rules are actually followed in practice, like training on them, monitoring it, etc. And so I think that's an interesting development that, of course, that new policy started and came out in November. People have had a chance to think about it, and it continues to be a big matter of discussion for internal compliance people.
Well, it almost seems like, certainly in the topics we've discussed in this podcast, that there are still some open questions. People are still looking for perhaps more clarification from the DOJ or SEC, yet are moving forward to continue to use the Evaluation of Corporate Compliance Programs document released in February 2017 and the new FCPA Corporate Enforcement Policy as a guide to further operationalizing your compliance program, and that the DOJ is, as you said, and it's perhaps evolving in its thinking as well.
Mm.
So, Nate, unfortunately, we're near the end of our time, but I wanted to ask one last thing. Is the FCPA Spring Review available on the Miller website? And if so, how would someone find it?
Oh, of course. Well, we try to make it the easiest thing for people to find. So, yeah, it is available on our website under publication. So, yeah, please give us a visit.
So I've been visiting today with Nate Lankford. He is a member at Miller Chevalier. We started off talking about the firm's FCPA Spring Review 2018, but really it gave us a platform to explore lots of different issues on where the Department of Justice has been, where they may be going. Obviously, the digital realty case and the new FCPA corporate enforcement policy. So, Nate, I really wanted to thank you for taking the time to visit with me today.
Thank you, Tom.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. Please take a look at my new book, The Complete Compliance Handbook. It's available on Amazon.com. I also have a flyer available about it on my website, www.fcpacompliancereport.com. I hope you've enjoyed this episode of the FCPA Compliance Report, and I hope you'll join me again next week for another episode. The FCPA Compliance Report is a part of the Compliance Podcast Network.